Civil 101. Pay attention. When it comes to cases in court, I'm sure you've heard of the phrases, "this case has been struck out" and "this case has been dismissed." Now, what do they mean? And what is the difference between them? Well, a case is said to be struck out when it is removed from the court's list of active cases for the day. But this does not necessarily mean the matter is finally resolved. So this means that a case that is struck out by a court can still be brought back to that court or a court of competent jurisdiction. So if you fail to file your processes properly or parties fail to show up in court, the case will be struck out. Now this leaves room for the claimant to remedy the issue and bring the case back to court. On the other hand, when a case is dismissed, it is deemed concluded and it cannot be brought back to that court unless the dismissal is overturned on appeal. So for example, if a court finds that there is no cause of action, the judgment will be based on the merit of the case, or in this case, a lack of merit, and the matter will end unless appealed. Now, when a case is dismissed, res judicata applies, meaning that the claimant is barred from bringing the same claim again to that court. So what is the key difference between them? Striking out is not final, and a struck out case can usually be relisted or refiled, preserving the possibility of future litigation. For a dismissal, however, the decision is final and is usually based on the merit of the case, and therefore, a dismissed case cannot be relisted or refiled unless that dismissal is set aside on appeal. Now that we know the difference, let's address one very important question. If a case is brought before a court and the court lacks jurisdiction to entertain it, will the matter be struck out or dismissed? The answer is, it will be struck out, and the reason is simple. Since the court lacks jurisdiction to entertain the matter, it simply won't entertain the matter. So they would simply order that the case be struck out so that the matter can be taken to a court that actually has jurisdiction to entertain it. Now let's flip it. What if the matter brought to court is one where the cause of action has a legal defect? For example, the claimant lacking local standard, or a claim that has been time-barred. Would the case be struck out or would it be dismissed? The answer is a dismissal. The reason is because the courts have gone through the facts of the case and have spotted that legal defect. So the judgment given will be based on the merit or lack of merit. Because the court has dismissed the case, the court cannot revisit this case unless this dismissal is overturned on appeal. Thank you very much for watching, guys, and remember, stay lawful, stay informed.